Jodie Bruning, you got a presentation, I think.
Yes, yep. Thank you. And there's a PowerPoint on its way. May I say how appropriate and wonderful it is to be speaking to elected representatives again. Yeah. Right. Since I spoke last, I'm a trustee and lead researcher for Physicians and Scientists for Global Responsibility. Since I spoke to many of you last in council chambers, I have a master's, sociology master's research. My research looked at the experiences of scientists attempting to get funding to research environmental chemicals as drivers of human health, particularly in regards to endocrine disruption. And so the reason you don't get scientists presenting to you is because the funding pathways are not there. So first of all, we would like to sort of simply, the context is the Director General misleading officials. Does the Health Act 1956, Section 116 now contradict other relevant legislation required to be considered by you as a territorial authority so as to protect health? And can you pause capital works without financial penalty? Next, please. So is it appropriate that New Zealand's gold standard for the safety of fluoride is established by a politically timed review from the Office of the Prime Minister Chief Science Advisor? So risk assessment is not a departure from the science, but it's being true to science. Next, please. So if we see here, we see the Office of the Prime Minister's Chief Science Advisor, the OPM CSA. Most of the peer reviewers were already focused on oral and dental health. When the Office of, next one please. So the review was politically timed one day after Supplementary Order Paper 38 was released by the Prime Minister's Office. As in 2014 with Peter Gluckman's, the 2021 paper had no methodology, peer review panel, and the peer review panel was exclusively with oral and dental health. No endocrinologists, toxicologists, or impartial epidemiologists were involved. The Cochrane study 2015 for fluorosis, they did not look at any other potential risk. So no risk assessment has ever been held. Next, please. So is it appropriate that risk assessment to judge pre-existing exposures in infants and children and risk from fluoride dosed into water by developmental stage and body weight has not occurred in New Zealand? Next, please. So this is Joseph on constitutional administrative law, obedience to convention. It is a convention that risk assessment will occur for hazardous substances. For medicines, it is a convention that they will go through peer-reviewed trials that are overseen for safety and efficacy. Next, please. So if we look at the select committee consultations, what we find is that the public have been written out of any capacity to critique the Ministry of Health's advice, declaration that fluoride should be in water. So in 2016-17 and 2021, both of them stated that we are not listening to any of the public discussing risk because it's not within the subject matter that we're talking about here, the content of the bill. So there has been no capacity for the public to come back with these concerns. Next, please. So beyond the subject matter of the bill, peer reviewers were oral and dental health experts, not impartial toxicologists. If we talk specifically about under 8-year-olds, because this is the group that are most at risk, they consume more by body weight and they retain more fluoride in their bones. And in fact, children will retain up to 80% of the fluoride intake in their bones, while adults will retain far less. Next, please. So as we see the science showing IQ harm is not going away, this NTP group did another review, just a quick review, and found that the consistently updated literature search will show continued harm. Next, please. Does the Ministry of Health and the Director General Section 116 undermine the Local Government Act 2002? Next, please. So what you see is you must identify and assess any other public health risk. So what's really interesting is that you have to improve, promote and protect public health. Now you can make bylaws specifically for this purpose. And I think, if I'm not incorrect here, that section 153 says that Crown is bound by any bylaw if non-compliance with that bylaw by the Crown would be likely to have an adverse effect on public safety. You may make bylaws for the particular reason for protecting public health. Next, please. Does the Ministry of Health and the DG's section 116 undermine the Water Services Act? Next, please. So what you have here is one line. It says other causes together with the consumption or use of fluoride water. So of drinking water, sorry. So you've heard Dr. Alana's comment on infant formula. So what we have is an understanding that children in New Zealand already have higher levels of fluoride in their urine than adults. And please note down there, the maximum acceptable value in the WHO is a 1984 study. If you go back through the drinking water guidelines, you will find that they have not reviewed the scientific literature. It's been locked in. Next, please. So we see here that you have rules, and if we look at the bottom right, we've received 911 notifications from local for notifications that exceed determined levels. Next, please. So your challenge, so navigating uncertainty is values-based. So the margin of error is, do cumulative exposures exceed 1.5? Now, exceeding MAVs is common. Children have toothpaste. That's not being taken into account, the exposures from toothpaste. We also know from the CPHR report that young children have higher urinary levels of fluoride. Next, please. So you are required to value, protect and enhance the environment. Fluoride has never, or hydrofluorosilicic acid has never, ever been risk assessed by the EPA. They have never, ever looked at fluoride and HFA emissions to water from Wellington or Auckland or Dunedin. There's no consents required. There's no fluoride assessed in the ESR's groundwater survey. And the margin of safety for children for example, pesticides is normally tenfold. So we should not be seeing a dismissal of a margin of safety for small children, but that's because risk assessment hasn't heard. So the gaps are ridiculous. Next, please. So the section 116 does not grant permission to put HFA in the municipal water, and that's what you're putting in. Now, the evidence bar for the Director General is that scientific evidence reducing prevalence and severity of tooth decay. If any one of you know children with terrible teeth, and particularly from low socioeconomic backgrounds, they will have 7, they might have 7, they might have 9. So what we see is all that Director General has to prove is maybe they've reduced their dental decay by 2. Then what we also see, next please, is that there is absolutely no requirement for, no legal obligation for the Director General to conduct risk assessment to assess safety. The section 116 is terribly, terribly drafted. Next please. So the court judgments, the courts have not tweaked, the judges have not realised that not undergoing risk assessment is outside administrative convention and that safety is not drafted into the legislation. So decisions must be reached justly and fairly and seen to be so. Next, please. Because what would a fair-minded lay observer say? So we're wondering, are there manifold inconsistencies and absurdities here? Next, please.
Sorry, can we wrap up? Please.
Yep. So there is a duty to warn. You have a duty to warn. This is from Joseph. This is the public law Bible for New Zealand. Next, please. Risk assessment is not a departure from the science, but it's being true to science. Next, please. So this is the questions we have. The Director General has made it clear he will not press for Hastings Council to conform to the fluoridation order they are under until future legal issues are resolved. So we request that TCC set up a process to further review the issues and options. You should be able to be recompensed for the money you've spent with the full knowledge that there is now an elected council that can actually make their own independent and impartial decisions. Thank you so much.